Good morning mga kaibigan. Welcome back to our lecture room. Ang pag-usapan natin ngayong araw na ito ay ang seller na korporasyon. Meaning to say, we have to know this seller which is a corporation. At ang mga dapat nating malaman ay as follows. Ano ang requirements kapag ang seller ay corporation? Number 2. Paano kapag ang corporation ay dissolved na? Bibilihin mo ba ang property kung dissolved na ang corporation? Yun po ang mga bagay natin na aalamin sa video lecture na ito. Alam ko may idea na kayo about corporation, yung secretary certificate. But again, I indulge you to watch and listen. Baka meron kayo ma-pick up ng mga new matters dito sa lecture na ito. Let us proceed. Ang tanong is, ano ba ang korporasyon? Now, basic definition of a corporation is that it is an artificial being created by operation of law. Ibig sabihin, ang batas ang gumawa nito. So, if you want to form a corporation, you make an articles of incorporation and bylaws, you execute, and you file it with the SEC and have it approved. The moment it's approved, then you now have a corporation. Yun yung in a nutshell on how to form a corporation. Okay. Now, but a corporation approved by the SEC, when it is an artificial being, ang nagpapatakbo talaga nito is mga tao lang din. And they are called the board of directors. Okay. And the board of directors, from among themselves, they will elect who is the president, the treasurer, the secretary, and the members of the board, yung mga board of directors. Ito sila. Alright. Now, pag mag-transact ka ng property at ikaw ang bibili ng lupa from a corporation, the thing that you usually receive would be this one. First is that they will show you the title under the name of the corporation. Okay. And then a secretary certificate by, let's say, ABC Corporation and executed by Juan de la Cruz, the corporate secretary of the ABC Corporation, and represented daw siya ni Jaime San Jose, president. Is that okay? Yes. I'm not saying it's not okay. Okay yan siya. As long as you really know that this particular corporation is existing and that what is stated in the secretary certificate is really correct. Na merong board resolution authorizing Jaime San Jose to sell the property of the corporation. Okay lang yun. Pero ako, meticuloso ako. When I deal with corporations as sellers, marami akong hinihingi. Okay. Number 1 that I ask is tax identification number o yung TIN verification slip from the Bureau of Internal Revenue and a certification of no pending case sa Bureau of Internal Revenue. Masyado ka namang strict to attorney? Yes, because in most cases, my experience would say that pag mag-process ako ng payment sa BIR and usually pag corporation tapos may open case, ni-hold ng BIR ang e-car, ang processing of the e-car, yung electronic certificate authorizing registration. Kasi nga, they would require that the open case of that particular corporation be paid first. Ibig sabihin, open case, meron silang obligation sa BIR to pay. They have obligation to pay some taxes and they did not pay. So that is an indication na talagang, well, this BIR medyo may problematic ito. Bakit hindi nakakabayad ng mga taxes sa government, diba? And yung tax identification number, oh yes, meron tayong yellow. Hindi yun. Kasi ang requirement ngayon ng BIR is that TIN verification slip. Kailangan ipa-verify mo yung TIN and they will issue a slip that it's verified. Hingin mo yun. No? Ang akin lang naman dito is we ask it from the BIR kasi gusto lang talaga nating malaman kung this particular corporation is in good standing. Okay? Na kayong minsan naiinis sa akin yung iba kasi stricto daw, meticuloso. Alright, meron pa akong hingin. I will ask, okay, from ABC Corporation, the following. Board resolution notarized. Kapag walang secretary certificate na napakita. Kasi gusto ko makita sa board resolution kung paano nangyari ang botohan. Ilan ang nagboto? Kasi ang basic rule is that majority of the board of directors present and dapat quorum sila. So kung 10 po ang board of directors, ang majority po niyan is 6. Dapat mag-vote approving the sale of the property. Basically. Diba? Paano kung ang nag-attend is 6 lang? Okay, quorum sila. Pero ang nag-approve is 5 lang, ayaw nung isa. Hindi pa rin siya majority. Hindi ba siya majority? Of the board present having a quorum? Is it majority of the quorum or is it majority of the board of directors? Yung kasi ang sabi ng batas, it's majority of the board of directors, hindi majority of the quorum. Okay? So, sometimes meron silang board resolution with secretary certificate. Okay yan. I will check how the votation was made. Okay. Tapos, I will also ask for the latest general information sheet. Remember that a corporation files a general information sheet every year. Pag hindi makapile yan, may penalty yan. Hindi po pwedeng hindi sila nakapile. Pag hindi sila nakapile, there's indication that something is wrong with this corporation. Hindi active itong corporation na ito. So at least kahit papaano, that would somehow put you on your toes na, teka, pag-aralan ko muna itong corporation na ito. Okay? Now, you will ask also for I also ask for the articles of incorporation and bylaws. Bakit? Kasi sometimes sa bylaws, meron silang higher requirement of votation para makabenta ng property. Hindi lang kay majority of the board of directors. Sometimes they would say 2/3 of the vote of the board of directors. Hindi majority. Iba yung 2/3. Mas malaki yun. Kaysa sa majority. Diba? 50+1 na yung majority. Kaysa sa 2/3, mas mataas. Tingnan ko lang. I just would like to check. And of course, a certification from SEC of the corporate status. Kung inactive ba itong corporation na ito or baka na meron ng issuance of revocation of its certificate of registration at sa period na siya na para pwede pa siya mag-lift ng revocation, baka kasi na-revoke or baka dissolved na siya. So yun ang mga questions that I would like to know before going into what I am dealing with. Okay? Now, so let us proceed though. Under the Revised Corporation Code, Republic Act 11232, this is a 2018 law signed by the President Rodrigo Roa Duterte that year. No? In cases kasi on regular sale, ang sabi kasi ng batas is that vote of majority of the board of directors. So, kung regular sale ng property, kailangan vote of the majority of the board of directors. Kasi what if kung hindi majority ang nakabote? Kulang. Then therefore, ineffective ang authority ng person representing the corporation to sell it to you. Yun lang po ang ibig ko sabihin. Meron pang rule sa Revised Corporation Code. Yung sale of all or substantially all of the assets of the corporation. Kasi baka yung property na binibenta, yun lang ang property niya ng korporasyon. Ngayon, ibebenta. Tapos pagtingin mo doon sa board resolution, majority of the board of directors nga. Pero sabi ng batas, dapat kasi both of the stockholders representing 2/3 of the outstanding capital stock. Mas mataas. Kasi nga, ibebenta mo nga ni ang substantially all or all the property or substantially all of the assets of the corporation. Sabi ng memorandum circular ng SEC is that to constitute daw na considered as sale of all or substantially all ang assets, sinasabi nila is, if the sale is at least 51% of the total asset based on amount of assets to be disposed, hulog tayo dyan sa all or substantially all. And therefore, it needs a higher votation requirement, that is, stockholders representing 2/3 of the outstanding capital stock. Take note, stockholders, hindi board of directors. Lahat na ng stockholders ang dapat magboto at kailangan 2/3. Okay? Now, how about kung sakaling pagtingin yun sa corporate status is that dissolved na ito? Ngayon, sa batas natin is that from the moment of dissolution, the effectivity of the dissolution. By the way, dissolution may be voluntary or involuntary. Voluntary yung sila mismo, let's say, pa-shorter nila ang corporate existence ng korporasyon, or they write that they would like to dissolve it, or that next is that may court order to dissolve. Yan yung involuntary. May violations sa SEC or na-revoke ang kanilang certificate of registration. Certificate of incorporation, not registration. I'm thinking of BIR, certificate of registration. Yeah, it should be certificate of incorporation na revoke. No? So, in that case, sabi ng batas ng Revised Corporation Code is that it remains to be a body corporate for 3 years. Yung board of directors, after the date of dissolution. Means yung date of the dissolution, effective date of dissolution. Bibilang ng 3 years. So 3 years na yan, pwede po ibenta ng mga board of directors by majority vote yung property. So if you are the one buying that property, tas dissolve na, huwag mo masyado matakot. Tingnan mo kung nandun pa siya sa 3 years. Kailan ba kayo na-dissolve? Let me see a certification from SEC kung kailan ka na-dissolve. Okay, so na-load, pasok pa sa 3 years. Pwede nyo pabilihin. Kasi, it is still a body corporate. Meaning to say, it could still act. The board of directors could still act, but purposes of liquidation and winding up of the affairs of the corporation. Hindi na to form into other business or to continue with the business kasi wala na, i-dissolve na sila. Pero yung liquidation and winding up process, continue pa yon. And one of the process of liquidation is to sell the assets of the corporation. So pwede po yun. But they have to do it within 3 years after the effective date of dissolution. Pag nandun ka, pwede mo bilihin. Ano ang exception? Kung meron silang na-appoint na trustee within the 3-year period, that is the only time that kahit na maglampas na ng 3 years, that particular trustee could continue selling. Kaya, kasi sometimes it's very impossible to sell all properties of the corporation within a period of 3 years from the date of effectivity of its dissolution. So, kakailanganin nila ng longer period of time. So, dapat alam nila ito, within 3 years, mag-appoint na kagad sila ng trustee to liquidate and settle all of these properties for purposes of winding up the affairs of the corporation. Yun po yun siya. Kasi after that 3 years, tapos wala silang trustee, they cannot already act in behalf of the corporation because they do not have any personality anymore. They are no longer a body corporate. Yun ang rule, no? So, suppose in this particular example sa regular sale is that hindi na vote of majority, tas secretary certificate is, for example, ang president at saka secretary nagkonsabo lang na, sabihin mo lang na mag-certify ka lang na majority of the board of directors tayo. Hindi pala. Umasa ka lang sa secretary certificate, binili mo, ineffective ang pag-purchase mo. Pwede ka masali sa intra-corporate dispute. Pwede kasi i-question ng any stockholders or even one of the board of directors. Hindi naman kami majority niyan. Yan, problematic ka tuloy. And paano kung sale or all of substantially all? Tapos ang nagbenta is majority lang ng board of directors. Sabi ng batas is 2/3, di ba? So, delikado rin ang pag-purchase. Paano kung dissolved corporation na tapos naglampas na sa 3 years? Hindi panla binibenta na sila, naglampas na sa 3 years, tapos wala silang trustee. Delikado rin ang pag-purchase mo. So, if any and all acts na ginawa na ganyan, ang tawag po niyan sa batas is ultra vires po. It's a Latin term which means it is outside the authority of these persons to do. Kumbaga, they do not have authority to do that. If it is an ultra vires act, it may be questioned. It may be questioned by anybody who has a vested interest in the corporation, like a stockholder or a member of the board. They could question that. Even creditors, no? Kasi they are interested of getting their money back, payment from that corporation. And even the government may even question that kung hindi na mabayad ng taxes. Ultra vires actions of this acts of this board of directors is actually punishable, and it is illegal act, and therefore it is possible that your sales instruction may also be considered as an illegal act. So yun lang ang gusto kong maintindihan ninyo. Kaya medyo technical konti, pero at least ang akin lang is my purpose in delivering this video lecture is to protect you buyers from these corporations. Di naman tayo masyadong stricto, pero well, that's your money. You want to spend your money, you want to purchase a property, so just be careful. Unless kung nagtatapon ka lang ng pera at ano. Alright, so ultra vires. Bye-bye. So with that, I would like you to remember always that due diligence is very important. It is the exercise of care and due investigation, which is normally expected for a buyer to do before entering into a real estate sales agreement with the seller. Like in this case, ang seller natin is corporation. So, itong due diligence na medyo maraming hinihingi, para naman sa kapakanan at protection mo yan as a buyer. So, be careful. So, we are finished with know the proof of ownership. We are finished with know how to verify land title. We are finished with know the seller. And next time, we will start with the conduct of ocular inspection. Kasi tapos tayo sa know the seller, no? And know the taxes and legal expenses. And number 6, find a real notary public. So, yun po. So, again, thank you for watching, and if you like my video lecture, please do not forget to subscribe, like, and share. Thank you. See you again next time.